glasses and grab whatever food you like, and we'll kick off now.
Sound effect. I'm more worried about the Mexican. And I written for
Okay, ladies and gentlemen, welcome to this evening's event of the British Chamber of Commerce in Thailand. My name is Stephen Frost. I'm a director of the board of the British Chamber. I'm also chairman of the Legal and Taxation Subcommittee. Our guest speaker today is Matthew Lloyd, who is Managing Director of Professional Wills Limited. Matthew completed his Business Administration degree in the United Kingdom and then went on to work in the finance and estate planning sector. Most of Matthew's clients were established professionals wishing to make appropriate provision for their family's future in their wills. He moved to Hong Kong in 2001 and has been drafting wills and advising clients on estate planning throughout Asia since that time. In 2008, Matthew joined Professional Wills Limited as a will writer, and he now supervises other will writers in the company and generally runs the office, which the head office of the company is located in Hong Kong. Although he's based in Hong Kong, Matthew regularly travels to Bangkok and other cities in the region to assist clients with will drafting and estate planning. Matthew is a member of the IPW, the Institute of Professional Will Writers, and is a full member of STEP, S-T-E-P, the Society of Trust and Estate Practitioners. Matthew has also completed STEP's Advanced Certificate in Will Preparation and an Advanced Certificate in Cross-Border Estates. Ladies and gentlemen, before I hand over to Matthew, our guest speaker, can I please ask you to switch off or mute your telephones so that the speaker is not interrupted in his delivery. After Matthew's presentation, we will have some time for questions and answers, and Matthew has also said he is able to take questions during the course of his presentation. So if you'd just like to wave a hand in the air, Matthew will deal with you. And could we have a nice warm Chamber of Commerce welcome for our guest speaker?
Thank you. Good evening, everyone. We call our talk the 6 things you've never heard about or don't know about writing your last will and testament, which I think people think is a somewhat depressing, somber type of topic, but creates a little bit of interest. And as we're chatting to a few people here, it's one of those things I think you say, yes, I really need to do that, I should do that, and I haven't done it. So we'll go through our 6 points, not in any particular order, but after we've gone through the talk today, then hopefully we'll have covered the answers to quite a few of these points. There's probably quite a few more than 6 that we could have talked about, but these are some of the most common ones that we talk about. Most of our clients are expats, like a lot of yourselves, and so we often find that they do have assets in quite a few places. And so I think gone are the days of trying to have a single will to cover half a dozen countries. So we often talk about how many wills people have, or how many people you need, how many wills you need rather. Following on from that, you've then got different laws in different countries. Thailand is a civil code country and it has very different laws to places like the UK or Hong Kong or Australia or the US, those types of places. So it's important to understand the laws which apply to assets in those different places. Of course, there's always tax to think about, and there's inheritance and estate taxes in quite a few countries. We're not tax planners, but we do have to know the tax considerations for people's assets when we write wills. There's a few practical points as well. A lot of people come in and they say, you know, we heard a friend died and their wife couldn't access the bank accounts, everything was frozen and there was problems, and you know, they think it's a travesty that you know, something's gone wrong along the way. But the practical parts of understanding what assets you've got and whether they're in joint name or separate name or somebody got signing rights on accounts is all quite important, and a lot of the work that we do is to make sure that if you die, the people left behind are able to access money and bank accounts and so on to avoid those types of problems. I think number 5 should be number 1 really, temporary guardians for children. Most of our clients are couples who've got youngish children and they're worried about what happens to the kids if they die, particularly overseas, if there's no family around. So the appointment of temporary guardians for children is important. The permanent guardian of the kids is often somebody far away in perhaps a home country. And so understanding the process of what would happen to kids if both parents were to pass away is perhaps the most important thing. The final one is to do with losing capacity, and we don't just talk about dying. Wills take effect if you die. When you die, you might also become incapacitated, and so that can be a problem as well in terms of who can handle bank accounts, who can access financial provisions for those left behind. So as we go through, hopefully we'll cover off some questions to most of those. As Steve mentioned, happy to take questions as we go through. We find it a bit more interesting with interaction. Somebody's lost capacity.
Incapacitated.
Absolutely.
Has he written a will?
It's a slipping glass.
It might be too late. Just to tell you a little bit more about who we are. So we're Professional Wills has its only physical office in Hong Kong. We've been there since 2006, but over the course of the years we've got about 2,500–3,000 clients, and naturally people from Hong Kong have left and they've moved to Singapore and Bangkok and different places in the region, and so over the years we've established serviced offices in the 4 places we mentioned there, and we travel to those places regularly to see new and existing clients. And we're able to write wills for, as we said, there are multiple jurisdictions, so we can write wills for most different places and people that we come across. And we also provide storage for wills. We've got half a dozen safes in our office, and so most people store their wills with us. We have regular review meetings, updates, and we write to our clients every year to remind them to keep the wills up to date, which is important. A lot of people have got a will and they've forgotten where it is, they've forgotten what's in it, it's probably out of date, and so writing a will is important, but maintaining it and keeping it up to date is equally important, I think. Does anybody have a will here? Oh, very good.
No.
Does anybody have more than one will? Oh, very good. 1, 2. It's quite unusual.
Does it? Okay. What I have done is I've handwritten on a piece of A4,
Right.
and put it in my safe at home, and I've shown my wife.
Yes.
And is that counted as a will?
Well, it depends. I don't know what it says. It depends on a few things. It depends how it's been signed and witnessed, first of all. So for a will to be valid, it has to be, in most countries, signed in the presence of 2 witnesses. The 2 witnesses must have signed in your presence to make it a valid document.
Oh, so it's not. So that's just probably my wish then, isn't it? That's
Right.
a wish in there
Yes.
too, but it's not
It
legal.
wouldn't have any legal validity.
Okay. Thank you.
If it hasn't been signed and
yeah,
witnessed, correct.
I'll get it sorted.
Okay. Now, we were talking a bit with a couple of people before about who can write wills. Now, of course, most people's thought, which is quite natural, is I need a will, I need to go and see a lawyer. Now, I'm not a lawyer, I don't have a legal background. Our firm is not a law firm of solicitors. We're a limited company who writes wills. So the option of writing your will, we do say you can do it yourself, but of course we don't recommend that. You can. Will writing is one of those legal activities which is not reserved for lawyers. You don't have to be a lawyer to write a valid will. You can go online, you can do it yourself, you can go to the newsagents and buy the kit, and if you've written it out and signed it and witnessed properly, you can write a valid will. So it's not something that has to be drawn up by a solicitor. However, of course you can, yes.
Is there a recommendation at which level you would go from W.H. Smith's document to something you're capable of?
I think
if you have 50 quid, why bother to get expensive wills? But
absolutely.
Is there a break point?
I think if you've got two people from the same country living in that place with a house and a bank account and a property, you might be able to get away with writing your own do-it-yourself will kit from the newsagents. I think whenever there's more than one jurisdiction involved, the will kit that you've bought in that country is not really designed to cover the assets in the other country. So then you do start to get into more complex issues. So I think any time there's more than one country involved, you shouldn't try and attempt to do yourself. I shouldn't really ever say that you should try and attempt it to yourselves. I think will writing is one of those things. Some people contact us and say, well, I'm not really worried, and I'm just going to try and do it myself. It's not very important. But we think about the sort of things that you're writing in a will. You're actually deciding who to give all of your money to that you've worked all your lives to accumulate. You're often appointing guardians for your children. You're appointing people to look after that money and to make sure it goes to the right people. So I think to try and do it yourself on the cheap, is never going to be the recommended way to do it. But you can go to a lawyer, and there are occasions when that's a good idea. The difficulty there is if you go to see a Thai lawyer, for example, they can write your Thai will perfectly fine. Lawyers are registered and licensed to practice in a particular country, often. So your Thai lawyer can write your Thai will, but they can't and they wouldn't perhaps be expected to write a will for another country because they're not licensed to practice or to write wills for other places. So we tend to find that lawyers are restricted in the work they can do. They can write perfectly fine wills for the countries where they are, but they can't write wills for the other jurisdictions. So as I said, we're not lawyers, we're will writers, and provided we can write wills which are valid and satisfy the requirements of the country that they apply for, we can write a valid will and it's perfectly valid and binding. So it doesn't have to be signed by a lawyer, it doesn't have to be notarized or lodged. It does in some countries, but by and large, most places don't have those requirements. Any more questions on that? Now, what happens if you don't have a will? So people say, oh, it's all right, if I die, everything will go to my husband or wife or kids or parents or whatever. But if you die with no will, you die what we call intestate. So every country has a set of rules which say, if you don't have a will, this is where the money will pass to. It's quite often not going to go to the person that we perhaps would have thought it would go to. And every country has a different set of rules from another. And there's kind of a pecking order to say where those assets would go. But of course you then lose control over your estate. It's not then your decision as to where your assets go. There may be excess tax that you pay because if you write a will you can usually make some tax savings if it's written in a certain way. And also you can't then gift personal items to friends and loved ones, and it says that you've got no control over what happens to you. I think that's to do with funeral wishes, because in the will you do of course say that you want to be buried, cremated and provide those types of wishes. And if you've died intestate with no will, then I guess you've lost the opportunity to make that clear as well.
Just a question here.
Yeah.
What's the pecking order for Thailand? Let's say you died intestate.
I like that question because my answer is always I don't know. What's the intestacy law in Hong Kong? I don't know. Why don't you know? When we write wills, the wills then override the intestacy laws. Now, we have a hard enough time finding out the laws for wills in all these different countries. So for me to understand what happens if you don't have a will for all those places, it's too difficult. So I don't know.
sorry. The reason for this is that, say if you knew the laws in Thailand or Hong Kong or wherever, and you knew that all the assets directly go to your wife, and say you've got a stepson or stepdaughter, and it may not be necessary that you can have a will if you know that the wills of this country automatically go to the wife. If you want to go to the wife, if you want to go to the stepson, then you definitely have to see a professional will writer or something.
Yeah, true.
It'd be good to know that.
Yeah, I think the only thing I'd say there is, for the other reasons, if we go back there to say the other problems with not having a will, when you write a will, you'll appoint an executor, for example. So if you don't have a will, you don't choose who's going to actually be involved in sorting out the bank accounts, dealing with the personal effects, going on to guardianship of children. If there's young children, then there's no guardian appointed. People say, what happens if we've got no guardian, and there's no will, and we die? Who's going to look after the children? It then becomes the court who's making an appointment of a guardian to look after children. And again, whether that would be the same person that you would have chosen is another matter. So it might be the case that if you don't have a will and the intestacy law says, well, everything goes to your wife, you might be happy with that. Beyond that, of course, if you both die, do the assets then go to the children? If so, what age do the assets go to the children? I was talking to somebody here just a minute ago, I forget who it was, and he was saying that you don't want money to go to children when they're 18, because what are they going to do with it? They're not going to use it wisely. So again, in a will, you can choose the age that your children would inherit the money. So you might say 25, 30, 35, at an age when the kids would be sensible and mature. If you don't have a will, kids would get the money at the age of majority, so 18 in most places, perhaps 20 here for certain assets. So I think with all those issues, most people say, well, yes, we'd like to get those appointments in place, and we'd like to definitely find out where the assets are going to go. So, as I say, for guardianship, if you don't have a will, the court would make a decision who becomes the new legal guardians of the children. When you've written a will, the appointment of legal guardians is then valid and binding, and so you would make an appointment in the will of those people. And again, the temporary guardianship one is really the one that a lot of people are worried about. If you've got expats in a country with no family or nobody nearby to look after the children, the concern over young children being taken away by authorities and looked after by strangers until family fly in is obviously a big reason for them to get these sort of things in place. People contact us all the time and say, I've heard that the kids get taken away by social services. We had somebody saying they're going to be taken to a Chinese orphanage, they've heard. It's great for business, but I mean, it's not necessarily true, I don't think. But, so again, making sure that all of those appointments are in place is obviously important. You then get a few unusual situations. There's a thing there about names on birth certificate. We get clients who are not married, clients who've adopted children, people in same-sex relationships who've had children, and again, you can only make an appointment of guardians if you're the legal guardian yourself and you have parental responsibility. So we have a lot of cases where one of the parents is the legal guardian of the children. The other person in the relationship doesn't necessarily have the legal entitlement to be a guardian. So the person with parental responsibility often needs to appoint their partner in a will for them to be a guardian in the event that that person dies. It's not necessarily when both couples pass away. Any questions on that? Okay. Executive trustees, I've talked about this a little bit. People often think, oh, it's all right if I die, my wife, husband, adult children, they'll go down to the bank with the will and they'll say, this person's died and please give me the money. And that's not going to happen, unfortunately. There's quite a strict process to go through, and perhaps for those of you who've had family and friends pass away, you'll have had some experience with this, but the probate of an estate is quite a lengthy, drawn-out, problematic process to go through. So if you're an executor, you have to contact a court in the country where assets are located, and you have to basically apply to the court to have legal authority to access the bank account, the property, the investment, or whatever the asset is. So it's quite a lengthy process to go through. You have to submit death certificates and passport copies and ID copies and lists of assets, and after quite a few weeks or months often of waiting, the executor is given a grant of probate, which is a piece of paper from the court, which you can then take to the bank, and you can then get the money from the bank. You can then sell the property, you can then change the names of joint assets, that type of thing. So that's quite a big job in most countries. I had a client yesterday whose father had just died a year ago, and his mum in the UK was dealing with a property and a bank account and some investments. It had taken her 8 months to do the probate of this chap's father, just in England, with a will. So that had taken 8 months to actually administer, to finalise everything, to do the taxes, to do the valuations of an estate. So you can imagine when you throw in 1 or 2 or 3 or 4 other countries, and this chap was saying that they'd almost bought a house in France. Go on.
Sorry, I didn't mean to cut you off. Just that we have an instance where it's taken over a year to go through probate,
Yeah.
and it isn't there yet. It wasn't a very big or complex estate. I mean, we'd love to hear what you think about methods of decreasing that duration.
Yes. Yeah, good question. Well, there's various things you can do. Now, the problem is no one knows when they're going to die, usually. And so, if you did, you might be able to plan for it quite efficiently.
I know I'm going to die, though.
Yeah. And so, if you then know who you're going to leave your money to, there's various things you can do. So, for example, a lot of people later in life will start to give away their assets while they're alive, for one thing. Now, there's pros and cons of doing that, because if you start giving assets to your adult children, that's okay. There's sometimes in the UK, for example, you have to survive for 7 years before they can be free of taxes. But you can give away assets. That's okay unless your adult children then get divorced, because then the money that you've given them goes into their divorce settlement, and that's lost in a divorce agreement, for example. So you have to consider that. But owning assets jointly with the person that you want to benefit is probably a good idea. In a couple of slides' time, I've got examples of assets which don't go through a will or you can avoid probate with. So where you've got joint properties, joint bank accounts, where you have life insurance, where you've named a beneficiary, quite often those assets would fall outside of a will and they transfer immediately to the surviving partner or the person who's been nominated. So those are probably some of the main things you would do to avoid that. The other thing that you would do is then set up a trust. And that means instead of you having your money in your bank accounts, you would open a trust, set up a trust, you'd move the money into a trust. A bank or a trust company would be the legal owners of that money. And so if you die, you don't own that $1 million anymore, it's in a trust. And that money can be immediately available to beneficiaries. But there's pros and cons, of course, of setting up a trust. There's fees and lack of control of your money, and some people don't like to do that. But those are some things that you can do.
How about a limited company?
Not really, because if you have shares in a company and you die, they're still part of your estate, and they would, if they're in your name, they still need to go through the probate before they transfer to a beneficiary. There can be benefits in owning assets through a company, usually for tax planning reasons. Doesn't necessarily speed up or avoid the probate.
But if you had a company, then the assets within the company, the cash flows, could be given access to other parties.
Yeah, possibly. You then get into, who are the shareholders, who are the directors, is there a shareholders agreement, what's the succession plan of the company? So if you're in business with a couple of other people and you're equal shareholders and you die, the person responsible for your shares is the executor of your estate. So you want to make sure your business can continue to run, to operate, that the staff can be paid and that suppliers are paid, etc., etc. But who becomes the new legal owner of the shares is determined by what's written in the will. So that needs careful thought and planning.
I think it was just in relation to his point, you could just put the assets into a company that doesn't do anything but hold the assets.
Yep.
But then you could easily have people with access to that without it being an ongoing operating company.
Or put your kids in as shareholders.
You could. So you can have a company. Yeah, you can have a company with yourself and your 2 kids as shareholders. But if you die, your shares are still your asset, and they have to transfer through probate from your name to the beneficiaries in the will.
But it doesn't freeze the assets immediately, I think is the point.
The company can still run on, can't it?
The company, well, it depends. It depends how the company's set up and how many directors there are, who can sign the bank accounts, and if there's a reserve director, there can be lots of things. It really depends on the situation, but it wouldn't necessarily make things a lot easier in my experience.
As this is Thailand and many of us will die here, are there restrictions on who can be an executor of the will?
Yeah, good question. No, you can appoint whoever you want as an executor. They don't have to be resident in Thailand. You might think for practical purposes it'd be handy if you've got somebody here to be an executor. Most clients that we see, they would appoint, if you take a husband and wife, for example, with children, if they both passed away, they typically appoint a brother, a sister, a close friend, or maybe 2 or 3 people in the will. And if you've got 3 separate wills, for example, you'd have the same appointments of the executors in all of those wills. And so really you should choose the people that you want to be involved and to act rather than where they are particularly. But if you've got one person here, you've got a brother in England and a sister in Australia, they would be able to sort of do the work in their respective places. So that's what we normally say. Yeah.
What is the difference between an executive and an administrator?
Good question. In Thailand, they're known as administrators, and the reason for that is because Thailand is a civil code country. Some of the language and the formalities for wills is different to places like the UK, Australia, Hong Kong, Singapore, the common law countries. So there's no particular difference in that case. An executor or an administrator of the will is the same thing. There's a slight difference in the terminology if you die intestate, and the people who would apply for, instead of the probate, they would apply for what we call letters of administration in the UK, for example. But administrators and executors are pretty much the same thing.
You said Thailand is a civil code country. Civil code as opposed to what? What is it?
Common law. So if you think of the UK, for example, and if you think the Commonwealth countries, most of those countries have a common law law. When you think of most of Europe, South America, some places in Asia, they follow a different legal system, which is civil code, Roman law, basically. And that just means that, of course, within those 2 different legal systems, there's different requirements of how to write a will, there's different succession laws. You take an example, if somebody has a house in France and they want to give it to their wife, they can't, because they have 2 children. The children are entitled to receive half of the property, as an example. Now in England, you can give all of your property to your husband or wife, there's no restrictions. So when we write wills, we have to make sure that the wills that we write don't conflict with the succession laws of the country that the asset is in or applies to.
So is that quite common practice to have succession laws which override your wishes? You mentioned the situation in France. I mean, I didn't know about that obviously quite well, but it sounds a bit harsh.
It does, doesn't it? Yeah, absolutely. Yeah, most people say, well, I want to give everything to my husband or wife, but if there's children in those countries, you can't disinherit children. Through the French laws and most European countries, children have an entitlement to often half or more of the assets, depending on how many children there are.
So what's the succession laws here?
Well, it's an interesting one. So Thailand, although it's a civil code country, there's no, we call it forced heirship. So the forced heirship is where you have to reserve a portion of your estate to children, like France. But in Thailand, a bit like China, they're both civil code countries, but you don't have any restrictions on how you can pass on the assets. So if you own a house here, you can give it all to your husband or wife. You don't have to include children or anybody else.
If you don't have a will, then it's different.
We don't know.
As I understand, that without a will, half goes to the children automatically.
Yeah, that's what I understand in Thailand.
Actually, basically, it's under Thai law. If you are married and you have legitimate children, right? And if you make a will, then you specific which one you're going to give to. And then if you're not specific or you don't make a will, then they will go half, 50% go to your wife, and then another 50% will be divided between your wife and children.
Yeah, in my case, I've got
And the wife gets a portion of that second half.
legitimate.
Yeah, that's right.
Yes,
Yeah, but in my case, I've got a son from another relationship and
Yes.
a new wife.
yes.
So
If
what
you
would
have
happen
a
is,
son with other ex-wife whatsoever, and that legitimate son, so then he can have a share
you will get half.
of another
You get
50%.
25%.
There will be one, another 50%.
But there's two 50%, so 50% goes to us.
Tell them what to do,
I should have found out.
So if there's one child and a
So
spouse.
75%, is it?
Yes, if you have a real article, so your wife will get 75 and another son will get 25%.
That's
But
correct.
if you doesn't want to give to him, then you specific on your will. You doesn't want to give to your son.
So I think in Thailand maybe then, because there's no forced heirship here, so therefore if you make a will, it sounds like you have, like most other countries, we say testamentary freedom. You do have the ability to override the laws and write a will and be specific about who those, which family members would be included, I think. Some countries you can't do that. Although, I think this is for next presentation, but there's been different changes in different countries where you can now select the law which you would want to apply to the succession of your assets. And that's been a new change, mainly to do with Europe in the last couple of years. So the laws are perhaps loosening up a little bit.
So what would happen if you had a mistake like that? For example, if you have assets in different countries and you sort of made a general will that says everything goes to the husband or wife, if one of those dies and if they both die, goes to the kids, something like that. And what if the law in one of the countries where you have one of your assets says differently? Does that like invalidate the whole will, or what does that mean?
It depends on how you've written the will. If you're able to specify a choice of law which would override the law in that country, it might still be okay. If you haven't, then if your will says I give everything to my husband, but actually you've got 2 children and there's a house in France, the children are probably still entitled to their half of the property. So those succession laws would and could still override what you've written in the will. The rest of the will is still okay, and you've always got a portion of your estate that you're free to give away. So again, from our side as will writers, we have to make sure that the wills that we write don't conflict with those laws. So knowing not necessarily the value, the ownership and the location of the assets and the laws which apply is quite important.
And is that the main thing, the not being able to disinherit your children?
How do you mean?
Are there other laws that would be surprising to us?
Oh, I see. No, I don't think so. I think that's the main one. The main one is the countries where they have civil code laws where children have an entitlement to inherit assets. Now, the gentleman mentioned child from previous marriage, which is very common. We had a very unfortunate case where this chap came in, he was in his mid to late 60s, and he got 3 adult children from his first marriage, who were all grown up, and we were going through our instruction form with him, and the final question we asked is, where do you want to be buried and cremated? He said, buried or cremated somewhere. He said, I want to include specific wording that my children should not attend my funeral. Blimey, should not attend my funeral. So this guy was married, had 3 kids, divorced, grown apart from the kids, was now in a same-sex relationship with another guy, and wanted to write a will saying, I give everything to my partner. Now, he was German, got 2 properties in Germany. So he came to us saying, right, I've got to write a will, very important, I give everything to my partner. And I said, gee, I'm sorry, you can't. He got quite annoyed. And I said, because you've got 2 properties in Germany, you've got 3 children. If you die, the 3 children have an entitlement to half of the properties in Germany. And he didn't want these kids to come to the funeral, so you can imagine he didn't want them to get any assets from the will. So that's a quite unfortunate example of how those rules can cause quite big problems. For a happy married couple with a couple of kids, if the kids have to get half of the property, okay, well maybe so be it, and people can work around that, but it can cause quite big problems with people's wishes.
And then can I ask about the role of the executor? Because depending on the freedom, say for example you left everything to your wife and you don't have children, then your wife dies immediately, does the executor have the freedom to decide who all these assets go to?
No, that should be written in the will.
But if it's not, it goes to probate.
No, it would go to, if you've written a will saying I give everything to my wife,
Yeah.
and then your wife has died before you and you die,
Yeah.
it's a pretty poorly written will for one thing, because you should always have the next provision to say, well, if you both die, what happens then? Okay, it goes to the kids or to brothers and sisters, and even if everybody dies, what happens then? So there should be 2 or 3 provisions of who receives the assets. In that case, if a wife dies and the other person, the husband dies, the assets would then be intestate, and they'd follow those intestacy laws.
So the executor doesn't have any freedom
No.
to decide anything?
That's right, no, they don't.
Okay.
The executor's job is to administer the will, basically. They don't have any flexibility or authority over who gets what.
Can the executor claim any reimbursement?
Sorry,
Can he claim any reimbursement for his...
Yeah, so executors are entitled to reasonable expenses for the work they do, and quite often they would engage professional help, and so professional fees can be claimed and paid from someone's estate as well, which is quite clear.
But for the executor, who decides the charges? Is there any reasonable limit? Who sets that?
Yeah, there's normally 2 executors in most cases. So if a husband and wife die, there's often a brother and sister appointed. And so they both have to agree. I mean, ultimately, if they're taking first-class flights around the world and staying in expensive hotels on the estate, then the beneficiaries are going to be the ones that are saying, well, hang on, you've charged too much there. So they've got to follow the definitions in the rules.
I was just saying that you can give the executor discretion in certain areas in the will, like for children under 18, or whatever, you could give them the benefit, the executive powers to give allocations for education and other bits and pieces.
You're right, yeah, and so that really falls more under a trustee. So we say, what happens if the kids are too young to inherit? So husband and wife die, 2 or 3 young kids, the will says we give everything equally to the children when they're 25 years old, that's it. So the brother and sister are the executors, they've paid off the bills, they've called in the estate. Their job then as a trustee, yes, is to manage those assets and, of course, make money available to the guardian of the children to pay for education and upkeep and pocket money. And so there is some flexibility there to decide how much money is given to the guardians. If the kids get to 22 and they're fairly settled and sensible and they need a deposit for a house, the trustees can agree to advance money earlier than the stipulated age in the will. So there is some discretion in that sense. And they've also, their job as well is to decide how they manage and invest the money. So, 2 parents die and there's half a dozen properties and millions of pounds. They have to decide what do they do with the assets. So they've got discretion to decide what do they do. Do they keep some of the investment properties? Do they sell them? Do they manage everything from one account, etc., etc.? So the job of the trustee is more of a long-term job. To look after assets, normally on behalf of young kids.
So in general, is the trustee and the executor 2 different? Does it need to be 2 different people?
They're normally the same people.
Okay.
Normally the same. They don't have to be. They can be different, but they're normally the same people. Yeah.
Is there a fit and proper test for a trustee?
Is there what?
Fit and proper test for a trustee?
Oh, good question. I'm not sure. To be a trustee, to be an executor, you have to have capacity to act. Certainly, if you're a trustee, then where trusts are created in certain jurisdictions, a trustee has a fiduciary obligation to the beneficiaries. So, if you're a trustee of a trust fund for other people, you become the legal owner of those assets.
Yeah, no, I'm actually from a trust background. That's why I was surprised with the appointment of an individual as a trustee. Yeah, that's what I don't understand, because I was thinking my background in trust is trust companies and that sort of thing.
Yeah.
Presumably your firm provides professional trustees and that sort of thing, or recommends professional trustees. But if it's just an individual who's got the responsibility of a trustee, as you say, they've got millions of pounds worth of properties, that's not a small task. You need to you are exactly what you're saying, aren't you? You're trusted with the masses.
You also have the person that has $50,000 worth, so you don't want to force them into having to pay a professional trustee, otherwise they're all just going to get triggered up in legal fees.
Yeah, sure, yeah. I mean,
I think
the
that's-
point is about the actual trustees themselves, like, can they be, if they can be anybody off the street, then that person has to recognise that they have a pretty serious responsibility.
They do, of course. And so, when clients are thinking who the trustees should be, typically they're close family members that they do trust. You're right, it's a huge job to be an executor of an estate, never mind a trustee. So if somebody becomes a trustee, it's quite likely that they would engage a professional trust company to help at least set up the terms of the trust and to give them the job of administering it. I think what people don't do these days is to appoint the law firm in the will as the executor, or to appoint the trust company in the will as the trustee, because you're then bound by their fees and their time, and there's no flexibility. People are happier to have their brother and sister appointed. They can then shop around and negotiate fees and decide which company they might need to engage or appoint. If clients work with a trust company, with a bank, with a financial advisor, their job is to leave information and to say, well, we'd like you to appoint this company, we'd like you to consult with these solicitors, because they're familiar with the estate. But it's more common that people would appoint individuals who might well engage professional help if required.
Ultimately, they've got a duty of care to the beneficiaries,
Yeah.
and so it's all going to be relevant based on the facts and circumstances and the size of the estate.
Yeah, sure, but technically speaking, any individual could be tasked with being a trustee of a massive estate, in which case that's a dangerous place to be because of things like taxes and that type of thing that can impact them.
But
The guy can make a mess of it, couldn't he?
That's up to the decision of the person.
Writing the will, of course, yeah, appointing trustee.
Excuse me.
People change over time.
Just in the program states that the executor has died just shortly before the will.
Hang on, sorry, go on, stop.
Just in case the executor has died just before the will holder has deceased, what happens?
Yeah, good question. So when we write a will, you'd appoint an executor. Again, you'd normally have a backup, one or two backups. But if the executor has died and there's no other executors appointed, the will is still valid, the terms of the will are valid, and then an administrator would be appointed to oversee the will. If the beneficiaries are adults, it's often the beneficiaries who would apply to administer the will because, of course, they have an interest in it. So the will is still valid, even if there's no executor still around. Okay, what else have we got? So we've talked about this a little bit. We've got international considerations, and again, the executors, the trustees, they need to be aware, and they probably won't be, they need to be aware of international issues, different laws, where you have property in a country, or bank accounts, or shares in a country. The treatment of those assets can be quite different, movable assets and immovable assets. And as I mentioned before, we talk about pensions, joint accounts, insurances. So a lot of those assets that would fall outside of a will. And when we see clients, we always make it clear that not all of somebody's assets would go through a will and go through probate. If, for example, you have joint property, if it's held as joint tenants, then if one person dies, that property passes to the surviving owner, regardless of what's written in the will, just by the legal ownership. Which, for a husband and wife, for example, if it's the family home, that's normally okay and it can pass to the other person. Where you've got a property as an investment with a friend or a sibling, you wouldn't want the property as joint tenants because you don't want your half to go to your sibling, you want it to go to your husband or wife, for example. So it's important to make sure you own the property then as tenants in common, as an example, so you can then choose to give that property away through the will. The main ones that fall outside of wills, again, are insurances. So life insurance, for those people who have death in service benefits with employers, those assets would fall outside of a will. Quite often pension benefits or some investments that people have, there's often an insurance element where a nomination of beneficiary has been made. So, of course, the important thing with that is that you make sure you've got the right person nominated. Plenty of people come in and they've still got their mum or their sister on the policy before they were married, and they haven't realised that that needs updating. So structuring that is important. What we don't do in a will, which I think I mentioned later on, is we try not to mention your assets in the will. We don't name the properties, the bank accounts, the investments, because of course they'll change over time. Your will can say, I give my estate to my wife, my children. So your estate is whatever you own as of when you die. You should, of course, keep a list of all of that in the will, so a list of assets, liabilities, things which will need some sort of attention. That's what you can keep up to date, perhaps without changing wills as well. Business involvements we mentioned before. We have plenty of people who come in and they've got a company and they've got half a dozen or 50 or 100 staff, and they've given no thought really to the succession of the company. You say, what happens to your company if you die? And they've really not thought about it. People are conscious of developing a company, growing it, but the succession plan is often left behind. So again, you don't put that in the will because your shares in the company just go into the will, but having the shareholder agreements in place, key man insurance, cross-option agreements, how do you value the company, etc., is all part of your business succession planning. So we try and point people in the right direction for that sort of thing.
I've got two questions. One, just going back to the joint accounts mentioned before. What happens then if you've got joint bank accounts? It'll automatically go to the spouse, will it? If you've got a joint with the wife.
The other half, the partner.
She doesn't have to, if it doesn't get ceased or doesn't stop.
You have to be careful because a lot of people think they've got a joint bank account. I had a bank account a few years ago, and then I got married, and I added my wife as a signatory on my bank account. So now we're both alive, we've got capacity, we treat that as a joint account. She does. Now, she might think in 10, 20 years' time, if I die, oh, it's a joint account, it's going to come to me. Well, it won't, because it's still my account. So if I die, that account would freeze, it would go through probate, and the account would pass according to what my will says.
But if it is actually a joint account, then
yeah. So a year or so ago, me and my wife went down to the bank with the passports, with the IDs, and we opened a joint bank account in joint names. So that bank account has what we call rights of survivorship, which means if she dies, the account defaults to me. If I die, it defaults to her. So the account shouldn't freeze. It shouldn't. The asset shouldn't be delayed. I say shouldn't because in some countries, Hong Kong included, you always hear stories of the banks saying, "Oh, somebody's died, we freeze the account," as a precautionary measure. But if it's a joint account in that sense, it should pass to the surviving person.
The other question I've got is that you were saying you shouldn't name your assets. Well, I've got a rule